In South Africa, however, if you miss this 12-month deadline, you can apply upon request to the registrar to extend that period by a further 3 months. So ultimately, the South African has 15 months within which to file a South African complete application. However, I have to reiterate that this is only applicable, this 15-month extension or period is only applicable for a South African provisional that is being completed. So if, for instance, the provisional application was filed in the United States of America and they miss the 12-month deadline, then they have lost their rights to be able to file the application in South Africa. This 3-month extension period is not applicable in that instance. So it has to be a South African provisional application that is being completed. So generally a 12-month period within which to file your complete patent application in South Africa. The applicant is then given an 18-month period within which to ensure that their application is in order. And as you'll recall from earlier today, the South African Patent Office doesn't examine applications substantively. Only formal examination takes place at the South African Patent Office. So what that means is that no examination takes place to assess the novelty, inventiveness, and applicability of that invention in South Africa. So as I said, you can file a patent application for the wheel and it will be granted. However, they do undergo formal examination, which means that is the application in compliance with all the formal requirements in terms of the Act? So are all your application documents submitted? Are the declarations in support of that application lodged? Is proof of the applicant's entitlement to that invention submitted? And this has to be completed within an 18-month period from the filing date of the complete application. However, within this timeline or even further timelines that are embedded in this. So from filing your complete application, certain documents have to be submitted within 6 months. So for instance, your declaration and power of attorney, your declaration relating to the use of indigenous and biological material, those documents have to be submitted within a 6-month period. Any assignment documentation proving the applicant's entitlement can be filed up to this 18-month period. So once the application is in formal order for acceptance, the Patent Office will then issue the acceptance notice to the applicant, which is confirmation that the patent application has been accepted by the Registrar of Patents and that it may now proceed to grant. Just to note that this 18-month deadline is extendable as well. So as a way of right, the applicant is entitled to a 3-month extension. So that will take it to 21 months. However, that must be made upon request, but the registrar has to allow that extension. Further extensions are also permissible, but they have to be, good cause must be shown. So you have to provide reasons as to why you are requesting any further extension beyond the 21-month date. And you might ask, what are the reasons for somebody wanting to extend this deadline for the acceptance? Well, what happens is, in many instances, corresponding applications are filed across the world. So the same invention, you're the same proprietor, but you have filed this application not only in South Africa, but in various countries across the world. And in most instances, those countries will undergo substantive examination. However, this is a time-consuming process. So what will happen is the applicant would rather wait for examination to take place in those foreign counterparts to receive an examination report and to amend the South African application to overcome any objections that may have been raised in foreign counterparts. And they will delay the acceptance because the requirements to amend the South African patent application is more onerous once it proceeds to grant. So it's easier to amend the application prior to it proceeding to grant. And that's why applicants will often choose to delay the acceptance deadline. Lambert, you've got a question?
Yes, Marco, thank you. On what legal basis or statutory basis does the Patent Office limit examinations to formal examination only? Are they fulfilling their statutory obligation to do a substantive obligation? They are?
Yes, they are. So I am aware, I'm on part of one of the committees that liaises with the South African Patent Office and the Patent and Design Law Committee. And a new Patents Act has been drafted, or a bill has been drafted that will hopefully go for public comment. We're not too certain when. It was supposed to be last year, March, but as with most things, it's been delayed. And that amendment will likely introduce substantive examination, because I'm sure some of our fellow attendees today are some of the examiners that have been appointed at the Patent Office. So for about 3 to 4 years now, the Patent Office has started training South African patent examiners together with the European Patent Office to examine applications. And they're actually in the final phase of their training at the moment, where they're undergoing a mock search and examination. So they've actually asked many of the IP firms to participate in this, to submit applications for examination. It is on a voluntary basis, but there's also no legal basis to the report. So it doesn't affect the grant of the patent or hold any standing. It's just merely for the examiners to gain experience in examining these applications and submitting reports to the applicants. And then it will also go through the objection phase and all of that, as would in foreign jurisdictions. Okay, but the legal basis at the moment is the registrar is only required to examine an application for formalities in South Africa. It doesn't require substantive examination. So the legal obligations are being met. But just so that you are aware that there are changes to the patent legislation that are forthcoming. Okay, so I hope you understand the reasons behind why most applicants wish to delay this acceptance deadline. It's in order to follow what is happening in foreign jurisdictions in order to amend the South African application. And also one of the reasons behind that is if they are issued with a search report where prior art is cited in that foreign jurisdiction, if the applicant is aware of prior art that can have an adverse effect on the validity of the application, and they lodge the declaration, which is the Form P3, that is a ground of revocation because they are making material misrepresentation, stating that there is no ground of revocation, which is one of the declarations in the Form P3. So if the applicant is aware that there is something that destroys the novelty of the application and they don't remedy it, then they would be making a false declaration with the application, and then the patent is open for attack on that ground that there's a material misrepresentation in the declaration that is submitted with the application. Yeah, but as soon as the deadline then expires and there's no request to delay the acceptance, the Patent Office will then issue the acceptance notice, as I mentioned, which informs the applicant that the application may now proceed to grant. The applicant then has 3 months within which to arrange for publication of acceptance in the South African Patent Journal. This 3-month deadline is extendable, but again, valid reasons have to be provided. However, very importantly, if this deadline is missed and no extension was requested prior to expiry of this 3-month deadline, then there's a lapse of the rights. So it's very vital that this deadline is adhered to, because if it is missed, you've lost all your patent rights in respect of that invention in South Africa. Okay, so if you do wish to extend this deadline within which to publish, you have to give valid reasons, and you have to file that request before the expiry of 3 months from the date of issuance of the acceptance notice. Similarly, if your application is not in formal order within this 18-month period or the extended period, the application will also lapse. So very important to keep note of the various timelines and the provisions in that respect. There is case law specifically regarding this period over here, and we'll discuss that a little bit later on. It's a University of Pretoria case that dealt with these timelines and the peremptory wording in the Act that states that if it is not published within the 3-month period, the patent application shall lapse. So for those that are in practice, it's very important to have a dependable and reliable docketing system to make sure that you as the agent never miss any of these deadlines. Otherwise, you'll have a very irate client knocking on your door. Okay, and as you know, the monopoly that is granted to the patentees for 20 years, and that date is from the filing date of the South African complete application. So not from the provisional, but from the complete application. Okay, and as I mentioned earlier, if we're looking at a foreign counterpart, so if there's a provisional application that stems from abroad that you wish to file in South Africa, you have to file it within 12 months. So there's a non-extendable period applicable. So if you miss the 12-month period, again, you have lost your priority rights. And it will follow then the same prosecution as it would normally in whichever country you're wishing to file the application. So as you can see, this 12-month is in terms of the Paris Convention, Article 4, whereas at the top here, it's in terms of the Patents Act, Section 31. Are there any questions regarding this process? Okay, that's very good. Please do take note of this, because this is something that will come up in the examination. Okay, so if we then have a look at the PCT process and entering the national phase in South Africa, again, you'll file your provisional application, although it's not compulsory. You can file a PCT application directly, as you can file a complete application directly as well, without any provisional patent application. So if you choose to file a PCT application, you have to file it within 12 months in terms of the Paris Convention. Then 16 months from the priority date, so the first date of filing the application in respect of that invention. The examination authority, the International Searching Authority, will issue you with your international search report and written opinion, which we did touch on briefly this morning. That is the opinion that is provided to you by the International Examining Authority regarding the patentability requirements. So whether the invention is novel, is it inventive, and does it have industrial applicability? Then within 18 months from the priority date in most instances, so for PCT applications, most dates are calculated from the provisional filing date. Just be aware of that. So within 18 months from the provisional application date, the international application will then be published. And this is published online on WIPO's website. It's called Patent Scope, where you can then access the patent specification and any documents that were lodged during the international phase. There you'll be able to find the examination reports and the like. So from this written opinion, you're then able to file what is known as an Article 19 amendment, where you wish to amend the patent specification. You're also able to file a demand. This is an optional step. And this is generally done in instances where you wish to overcome any objections that were raised by the examiner. So with your demand, you will file a new set of claims or a new set of amendments, and that set will then undergo examination by the searching authority that you have elected. So from this step, 28 months from this priority date, then you'll then be issued with the International Preliminary Report on Patentability, which is the examination that was undertaken when you requested this demand for the new set of claims or amendments that were made to be examined. So if this step is not elected, if you don't file a demand, your ISR and written opinion will basically be considered your IPRP. Then you have to nationalize the international application within either 30 or 31 months from the provisional date. So again, all the dates for the international application are based on the priority date. So within 31 months after going through this period, you then nationalize the application in the countries where you seek to enter the national phase and to obtain granted rights. So within 30 or 31 months, depending on what has been included in that country's legislation. So for South Africa, it's a 31-month period. Okay. It is possible in South Africa, the Patents Act makes provision in terms of Section 43(3) to extend this deadline by a further 3 months. No reasons are necessary, but it is an application that must be made when filing the South African national phase application to request for late entry into the national phase in South Africa. So you have an additional 3 months within which to file the application in South Africa. So a far more lengthy process, but the benefit, as we said this morning, is that you are provided with this examination report. You are afforded the opportunity to amend it before entering national phase to overcome objections, so that when you enter the national phase in various countries, your costs may be limited, as you're not required to then amend it further to overcome those objections, unless they themselves find any invalidities in the application in that specific country. Any questions on this? No, okay. So then once you enter the national phase, that further prosecution that takes place in that individual country. So at this stage, the applicant or their agent will instruct the patent attorneys across the world in the various jurisdictions to enter the national phase, and then it will undergo that country's further prosecution until a granted patent is issued. Everyone very comfortable with this? It is a very important bit of the work. Okay, fantastic. Last year I had a lot of questions. I'm surprised there's nothing this year. It's a good sign. There's improvement. Just also very important to note is that the national phase filing date. So when you enter the national phase filing date, the filing date in the national phase is actually the PCT application filing date. So your 20-year monopoly, once the patent is granted, extends from the international filing date and not from the national phase filing date. Okay. The next few slides, we're briefly going to run through it. I mean, this is quite self-explanatory and self-study. It's basically the form of the application, the documents that are required in respect of the application, and so forth. So looking at section 31, the patent application shall be made in the prescribed manner and on the payment of the prescribed fee, and shall be accompanied by a provisional specification or a complete specification. So remember, you can either file a provisional application to secure your priority dates and to further develop, or to conduct market research and obtain funding, or you can file a complete specification. Then Regulation 22 of the Act says that, of the Patents Act says that an application for a patent shall be made on Form P1. So that's for a provisional and a complete application. For national phase patent application, it's a Form P25. And with your application, you need to file the Form P2, which ultimately becomes the register sheet in the patent register. You also need to submit the declaration and power of attorney on the Form P3. Very vital document. As I said, several issues can arise if a false declaration is made on this document, and potentially can leave the patent open for revocation if there is a false representation. Then you also need to submit an assignment or other proof of the right to the applicant to apply. So if it is somebody other than the inventor that is filing the application, they need to show proof that the rights to the invention have been transferred to the applicant. And this is usually done by way of a deed of assignment, which is a contract between the two parties saying that inventor A has assigned his rights to the invention to company B in this instance. There are several ways in which the rights can be assigned. It can be by way of employment contracts, it can be by statutory provisions, but in most cases, it will either be by way of employment contract, where there is specific provisions in an employment contract for the transfer of the rights from an inventor to their employer, should that invention be created in the course and scope of the employment. Then the cover page of the specification. So for provisional specification, it is done on Form P6, and then Form P7 for complete specification. Any drawings, if necessary, to exemplify the invention, so to illustrate what the invention is, and then also an abstract, which is accompanied with Form P8, and also a publication drawing, if necessary. Then an amendment to the Act was the inclusion of Section 33A, which came into force in 14 December 2007, where an applicant is also required to lodge a Form P26. And the Form P26 is a declaration stating whether the invention relates to biological, indigenous material, or indigenous knowledge or use, or traditional knowledge. If that document is signed in the positive, where the invention does relate to any one of these, then further provisions will come into effect. In most cases, these are false or negative declarations where the invention doesn't relate to any of these. This document has to be submitted with every application in South Africa. So even though it's an invention that relates to mechanical technology, I mean, the mechanical technology won't fall in the ambit of any of these. It is still necessary to submit the Form P26. And again, if a false declaration is made on this Form P26, so if the applicant attests that the invention does not relate to South African biological material or indigenous knowledge or genetic resource, but in fact it does, then the patent can also be revoked because of a false misrepresentation made on the Form P26. Okay, Regulation 22 just introduces the form that needs to be used for that. Again, Section 33B then deals with issues. Patrice, you have a question?
I just want to check the Form P26.
Yes.
Does it also get filed for provisional or just for complete?
These should be submitted with the P26 is only for a complete specification. So it's not necessary to file it with a provisional, no. Only for a complete specification. Yeah. The P3 must be accompanied with every application, however. I mean, the reasons why this was introduced was to to ensure that the communities that are privy to this traditional knowledge or use, or have acquired this information or this biological resource from an indigenous community, that those communities are able to benefit from that invention. So if the invention does relate to that, then there must be some benefit sharing agreement set in place that they are able to also benefit from their knowledge of this invention. A prime example was the situation of the CSIR and the Hoodia plant. As you may know, I don't know, some of you may know the story, but the Hoodia plant was used by the Khoisan as an appetite suppressant. So in times of drought where they couldn't source food, for instance, or couldn't go hunting, they would eat on the Hoodia plant, which would suppress their appetite. And this was then later exploited by the CSIR, extracted the compounds, processed it, purified it for human consumption in a tablet form as a diet pill. So you can see this was knowledge that was known within the Khoisan community, which was then taken on by a more commercial endeavor. So that's one of the reasons why these provisions came into play, was to ensure that there is some benefit sharing agreement in relation to inventions that do stem from indigenous resources or knowledge. So if we have a look at section 33B, then the registrar shall call upon the applicant to furnish proof in the prescribed manner of his authority to make use of the indigenous biological resource, genetic resource, or traditional knowledge or use, if the applicant lodges a statement that acknowledges that the invention is derived from indigenous biological resource, genetic resource, or traditional use. So you must show proof that they have actually been given or been authorized to make use of that. So if any bioprospecting takes place, there must be proof that they are authorized to do so. And this just provides some of the proof in terms of regulation 33B. So where there's a permit issued in terms of the NEMBA, which is the National Environment Management Biodiversity Act, where a bioprospecting permit is issued, proof that there was prior consent obtained in terms of NEMBA, that there is also a material transfer agreement. So there has to be a material transfer agreement in place as well if bioprospecting took place and the invention relates to that, as well as the benefit sharing agreement, so that that community is justly rewarded for their knowledge. Then also proof of co-ownership, that they are also then co-owners of the invention, and any other proof that satisfies this requirement to the registrar. Just having a look at some of the further provisions in terms of the regulations. So there is you have to have an assignment of the proof to the satisfaction of the registrar of the applicant's right to claim priority. So it may happen that a provisional application was filed by company A, and they have assigned those rights to that priority application to company B. So once it's completed in South Africa by company B, there has to be proof that the rights to that priority application have been transferred from A to B, that B actually is entitled to claim that priority date as the priority date for the invention. So it's a separate assignment from an assignment of the invention. An assignment of invention will always stem from the inventor, where the inventor has developed the invention, where his rights or her rights have been transferred to another party. Then together with the complete application, you have to file a copy. If it's from a South African provisional application, you have to file the Form P2 of the provisional application, as well as the specification and the provisional application that was filed with the South African provisional application. If it's a priority application from a foreign jurisdiction, so if I'm claiming priority from an Australian application, you have to file a certified priority document. So a certified copy of the document that was lodged at the Australian Patent Office. And this has to be translated into one of the official languages of South Africa. Then every application must contain an address for service, which is included on the Form P3, that every application is required to have in support of that application. Okay. So how do you secure a filing date? So you may not have your specification ready and you wish to obtain a filing date. So there is a minimum filing requirement that must be met in order to secure that filing date. You obviously have to pay the 590 Rand to the Patent Office. The form, either Form P1, has to be submitted to the Patent Office. The patent specification can be filed, but provision is also made for the late lodging of the patent specification. This has to be lodged within 14 days if it's not submitted at the time of filing the application. And then also any of the drawings that you wish to file. So basically you have to pay the filing fee and you also have to complete the application form. You are able to obtain the filing date without the specification, but then as I said, you have to file it within 14 days from that filing date. Again, if it's a convention application, so an application that comes from abroad where you're claiming a foreign priority, if the specification is not in English or one of the other official languages, you have to then submit a translated document at South Africa, so the translated form of the specification within 3 months for complete applications. So ones that stem from the Paris Convention within 3 months. If it's a national phase application, you have 6 months within which to file the translation of the official language of South Africa. Any questions so far? Yeah, all good. As I said, not very riveting stuff, very procedural and formal. Then moving on to section 37, it also provides that the priority claim may be amended in the application within 2 months from lodging that application. So these previous provisions mostly are applicable to provisional applications or complete applications that are filed directly in terms of the Paris Convention. If we then move on to the form of the application for national phase application, as I said, we have to file the national phase within 31 months from the earliest priority date, with a possible 3-month extension that must be requested at the time of filing the application if you miss the 3-month deadline. In this case, again, you have to pay the 590 Rand to the Patent Office to file the application. And if, again, it is not in English during the international phase, you then lodge the translation with the South African application within 6 months. And as I already said, the Form P25 is analogous to the Form P1 for the complete and provisional applications. Okay, if we then move on to section 31, section 31 basically says from what you can claim priority from. So you can claim priority from a prior application, which is accompanied by a provisional specification. So that is, if you file a provisional application, you can claim that priority, or you can claim priority from a complete specification. So if, for instance, in Australia, you filed a complete patent specification without a priority claim, you can still within 12 months file an application in South Africa and claiming priority from that complete specification. Okay, So remember, it just has to be the first application in respect of that invention from which you must claim priority. Again, this is that it has to be requested within, or the application must be made within 12 months. It can be extended to 15 months if it's from a South African application. And then again, just going into foreign applications that are being filed in South Africa, that it can only be done within a 12-month period. And again, just reiterating in this section that there must be the right to file that application in South Africa. So there must be proof that the rights to that in priority application have been transferred to the South African applicant. As I said in most, or as I've reiterated throughout the day, you have to claim priority from the first invention in respect of that invention. Sorry, but before I go ahead, I see Nicole, you have a question.
Hi, I just
Yes.
want to find out if you file a provisional and then within your 12 months file a complete and then extend your rights internationally, but in your complete you did not claim priority from your provisional. When you file your international application, do you then only claim priority from your complete application in that instance?
Yeah, so if your South African application doesn't include that claim to priority, that provisional application will only become a public document once it is actually completed and proceeds to grant. So as long as it never proceeds to grant, with the claim to that priority, which in this case it wouldn't, because you're not claiming that priority, then it will remain a secret document. So in that case, the complete application will be considered the first application in respect of that invention.
Thank you. So in that case, you're only losing out on the time in respect of
Yeah.
the priority claim.
That's correct, yes.
Okay, thank you so much.
Pleasure. So yes, it's a good point that Nicole makes. If you do miss the 12-month deadline within which to file the complete, you can either refile your provisional application and obtain a new filing date, or you can just file the complete, and that will then be considered the priority date for that invention, provided that the provisional is never made a public document. And this briefly goes on to the next section, sections 32(1)(a) to (c). As I said, it must be the first application for the subject matter in that country, provided that it does become a document that's open to inspection. If there had been an earlier application, which is what Nicole was touching on, is that previous application must either have been abandoned, withdrawn, or refused without being open to public inspection. So this is exactly the point that of Nicole's question. If you did file a provisional application, you don't necessarily have to claim that priority from it, but you must make sure that you've either withdrawn the application that you filed or you've abandoned it. So you've never actually completed that application previously, or the patent office refused it, and obviously that it was never open to public inspection. Then there must also be no priority rights on that application. So if you have filed a complete in that instance, you must make sure you won't then be able to file another application if there was an application filed with that claim to priority, and then also no rights outstanding on that application that was completed elsewhere. If we then look at the contents of the specification, this is provided for in section 32. It says every specification shall indicate whether it's a provisional or a complete specification. and that is either done on form P6 or P7. That requirement's not necessary for a national phase application, however, and it shall commence with a title. So your specification must have a title which indicates the subject matter of the invention. The provisional specification, as I said, must sufficiently describe the invention, and it's not necessary to include the set of claims. However, your complete specification with that application needs to include the abstract. Specification has to sufficiently describe, ascertain, and when necessary, illustrate or exemplify the invention and the manner in which it is to be performed in order to enable the invention to be performed by a person skilled in the art of such an invention. So again, reiterating what I've said earlier today, this is one of the grounds of revocation if this requirement is not met. So where your patent specification doesn't sufficiently describe the invention or illustrate or exemplify it for somebody that's skilled in that art to be able to perform that invention, then it is able to be revoked based on that ground. Then at the end of the specification, it ends with the set of claims, which defines the scope of the protection and the scope of the invention for which you're seeking your monopoly rights. Then section 32.4 says that the claims shall relate to a single invention that shall be clear and shall be fairly based on the matter disclosed in the specification. So your application for a patent can only relate to a single invention. It has to be clearly defined what the invention is. And what you are claiming in the claims must be fairly based on what you have disclosed in the specification itself. So you can't include a claim that is unrelated to the subject matter that hasn't been disclosed in the specification itself. So if, for instance, the specification defines this bottle as the invention, it's a very rudimentary example, but the claim is for this bottle itself. And the disclosure in the specification is only for this bottle. You can't introduce a claim for the cap as well, if that makes sense, because there was no disclosure of the cap in the specification. It was only a disclosure of the bottle. So your claim can only relate to the bottle itself and not to the cap. If necessary, and also any drawings and so forth. Again, please just read through this at your own leisure as well in preparation for the exams. Looking at the priority dates in terms of section 33, the priority dates of the invention will be the date of lodging of the earliest of such prior applications in which that matter was disclosed, insofar as it is fairly based on such earliest application. So what is important to highlight here is that when you complete your application, it should still be fairly based on what the disclosure is in the priority application. Okay. So you can't add necessarily new subject matter and wish to obtain the priority date if you haven't disclosed that matter in the provisional application. It's also possible to claim priority from several applications. So you don't only have to file one provisional application, you can file multiple. But when you complete the application claiming the multiple priority dates, it has to be from the earliest priority date. So your 12 months will always be from the earliest filing date. And the reason behind possibly filing additional provisional applications is that during your development, you may come across a new part of the invention, you wish to further develop it and seek protection for that. You can then file that provisional application for that subject matter as well. But when you file the complete application, you'll include the subject matter of both provisional applications and claim priority from both of them. So then how would the courts assess it? So in determining whether an invention claimed in an application is fairly based in the prior application or prior application in the convention country, so if it's a foreign priority claim. Regard shall be had to the disclosures contained in all documents at the time and in support of that application. So it just says that there has to be fair basis for what is being included in the complete specification from the provisional application. As I said, you can claim priority from more than one application. If we then move on to conversion and post-dating, this is provided for in section 38. So it is possible to convert a complete application to a provisional application. And one of the reasons for doing that is in order to buy you more time to further develop the invention or to secure more funding. So the registrar on request can at any time before acceptance of the complete application, but not later than 12 months from the date on which the application was lodged at the patent office, convert the complete application to a provisional application. So if you've filed a complete application, you can request that the registrar convert it to a provisional application for South African application within 12 months. So the application must not have been accepted and it has to be done within 12 months from the filing date of the complete application, where it is then converted to a provisional application and it is kept a secret document, because once the complete is granted, it's no longer kept secret. So the provisional is then kept a secret document, and you can then later on complete it again from that converted filing date. You'll then claim priority from there. Then it also affords the opportunity to the applicant to post-date an application. So this must be done before acceptance of the complete specification. The registrar may, on request by the applicant, post-date such an application, provided that the application is not post-dated more than 6 months from the date on which it was lodged. So you have to do it within a 6-month period from within which filing the application. The application that claims priority may not be post-dated to a late later than the last date on which it was able to validly claim priority. So if you file an application that claims priority, you can't extend it beyond the period where you would no longer be entitled to that priority claim. And then again, no rights are allowed to be left outstanding. So you can't have an application with that priority claim in a foreign country, for instance, where it hasn't gone through the final prosecution or either been withdrawn or lapsed or refused. The reason why applicants may wish to post-date is to obtain more time to put their application in order and to increase the length of the term of the patent which may be granted for the application. But it is something that's quite risky to do, because there can be an intervening novelty destroying occurrence that could then leave your patent open for attack later on the basis of novelty. There's also a risk that other countries, when you wish to complete in those countries, might not recognize the post-dated filing date as the earliest date from which priority is claimed. And this is in respect of provisional applications, just to be clear. Are there any questions on this so far? Okay. Okay, then moving on to section 34 in regulation, which provides for the examination of the application for the provisional. Just says that the registrar shall examine every application, and if it complies with the requirements of this act, he shall accept it. Again, there's no requirement in the act for substantive examination, so that's why it relates to the formalities only. And then an application accompanied by a provisional specification shall be examined to ensure that the documents are legible and capable of reproduction. So is the text, are the drawings capable of being reproduced by way of photocopying, and is it actually legible to a party? Then something that we've reiterated numerous times now is that once you file your provisional application, you can file the complete within 1 year, or you can file the PCT application, or you can allow the provisional to lapse by not completing it, in which case that provisional document will remain a secret document. That's now looking at completes. Again, in terms of section 34, the registrar has to examine every patent application or every complete patent application. And again, if it complies with requirements, it has to accept it. You have to comply with all the formalities in terms of the regulations. Again, not anything of much interest here, and that you can read at your own leisure once more. If the applicant is required to remedy any defect upon request of the registrar, they have to do so within a 3-month period. So if, for instance, you haven't submitted your form P3, the registrar will issue an official action calling for the submission of the outstanding document, for in this case, the form P3, and you have 3 months within which to submit that document in response to the official action. That 3-month period is extendable upon request to the registrar. If you don't comply with the provisions of this regulation, so you don't submit the P3, you don't respond to the official action, and you don't request an extension, then the application is deemed to be abandoned. Let's see. I think, should we break for a quick 5-10 minutes, or shall we continue?
Well, let's break.
We want to break. Okay. Let's take a quick, let's say 9 minutes break. So we'll come back at 2:15.
Thank you.
Okay. See you all at 2:15. Okay, welcome back everybody from the short break. It's the last stretch for today's workshop, and then I'll see you all again tomorrow at 9 o'clock. So as I said, last stretch. I can see there's some yawning faces every now and then. And thank you for bearing with me today, and I hope that this is more understandable to some of you. I know that it's a lot to absorb and to take in, but I will afford you opportunities again for any questions that you might have tomorrow. So then let's cracking on so that we can finalize the day. So if we now look at section 40 that deals with the lapsing of applications, I did discuss this to some extent earlier when we were looking at the various timelines when filing an application. So in terms of section 40, if the application is not accepted, so the formal requirements haven't been complied with in terms of the Act in respect of the application for the patent within an 18-month period for priority applications that have been filed directly in South Africa, or complete applications, or within 12 months for national phase applications. These timelines do differ between the two. So for a national phase application, it has to be placed in order for acceptance within a 12-month period from filing the application in South Africa, whereas for a convention application in terms of the Paris Convention, it has to be within an 18-month period. So if those requirements are not met, the application shall lapse unless an appeal is filed to the registrar. If the delay is not due to the applicant's fault, and this is the case every day in practice, is that there are administrative delays at the South African Patent Office where the notice of acceptance is issued well beyond the 18 or 12-month deadline. In that case, it's not the applicant's fault. There's no act or omission on the part of the applicant, so the application does not lapse in that instance. As I mentioned as well, this deadline is extendable on application to the registrar. The first application is for 3 months, which must be granted by way of right. Any further extension must be made with good cause shown. So any application beyond either 21 months or 15 months does require that good cause be shown as to why you're requesting the extension for the acceptance deadline. And as I said, for South African applications, the most common reason that is request or used for this request is that the applicant is awaiting examination in further in foreign jurisdictions, so as to align the South African claims with the foreign counterpart and to ensure that there's no novelty destroying prior art that is raised during foreign jurisdiction, during foreign examination. And again, as soon as the registrar is satisfied that all the formal requirements have been met, he will then accept the application and give notice to the applicant on an acceptance notice, which is then accompanied by the Form P8. And the Form P8 is the document that contains most of the bibliographic details of the applicant. So, or for the application, that includes the applicant's details, the priority claims, the classification of the invention, and as well as the abstract and publication drawing. And that is ultimately what is then presented in the patent journal once it is published. So the notice of acceptance then includes the date of acceptance. And as you'll recall, it has to be published in the patent journal within 3 months from this date of acceptance. The Patent Journal normally publishes the last Wednesday of every month in South Africa. Depending on the holiday season, it might be sooner. And as I said, this was a subject of contention in the University of Pretoria case, where the applicant failed to timeously publish the acceptance notice in the Patent Journal, and no request was made prior to expiry of this date. Request was made after the 3-month period that is allowable for a request to extend the publication date. And the court held that because of this peremptory wording from section 42.3, that if the application is not published timeously, the application shall lapse. Just to put it into practice, this is a picture of what the acceptance notice looks like from the South African Patent Office. As you can see, not a very nice looking document or very clear, but this is a notice of acceptance. And then once this is issued, from this date, you have to publish acceptance with the details of the Form P8 abstract, and if there's a publication drawing within the Patent Journal within 3 months from that date. And the onus is on the applicant to arrange for publication. So the Patent Office won't automatically ensure that the application, the acceptance of the application is published. The onus is on the applicant to ensure publication takes place. A very important case in practice, one that can sometimes give you a headache. It is the University of Pretoria versus the Registrar of Patents case, which I have discussed quite extensively, but please do take note of this court case and familiarize yourself with its findings and the facts of this case for examination purposes. So if we just have a quick look at it, what the findings of this case were that if at the date when the acceptance of the patent application is due and there's been no request for an extension of the acceptance period, the patent application is not in order for acceptance and the patent application lapses. Okay, so that is something that we do know. If you haven't placed your application in order for acceptance within the timeline that's prescribed, so that's either the 18 or 12-month timeline, if you haven't placed it in order and you haven't requested suitable extensions, then the patent application will lapse. There's also no possibility of extending the period for acceptance further after the date when acceptance is due has passed. So any request should be made prior to the expiry of that deadline. So if your application is not in formal order by that period and you only request that extension after expiry of that date, it won't be an allowable request. And again, the application would lapse. However, in practice, these extensions are done after the expiry of this date, but in those cases, the application would be in order for acceptance, and the registrar will allow those applications. Again, section 42.3, which we discussed over here, that the application shall lapse if publication is not or does not occur within 3 months from the date of issuance of the acceptance notice. And also what I have reiterated is that any request for that late publication has to be done before expiry of the 3-month period within which to arrange for publication. Are there any questions that you might have for me regarding acceptance and the lapsing of applications? No. Okay. So when does the patent or patent application actually become something that forms part of the public domain? So when is the public actually able to access the patent or the application? And this is dealt with in terms of section 43(1) to 3. And what it basically says is that if the South African application claims priority from a foreign application, So if it's an invention where an application was filed abroad and you filed a patent application in South Africa with that claim to priority from abroad, then the file at the patent office will become open to public inspection after 18 months from the earliest priority date. So from that priority date, so if we take the Australia example again, if you're claiming priority from that Australian application, it will become open to public inspection within 18 months from the filing date of the Australian application. Okay, so not the South African application, that's from the earliest priority date. If, however, it's a South African application that claims a South African priority, then it will only become open to public inspection upon grant. So if we have a look at the foreign example again of the Australian application, if grant occurs prior to the 18-month period from which priority is claimed, then the date of grant is when the file will become open to public inspection. Then Section 44 provides for the sealing and grant of the patent. So the patent is to be sealed, which is the issuance of the letters patent document, which is that document I showed to you earlier this morning. The patent office is required to issue the letters patent document as soon as possible after publication. Unfortunately, it does take some time to obtain the letters patent document. It can range from a couple of months to 1 to 2 years before you obtain the patent certificate from the patent office, but it is effective as from the date of publication. What is also important to note is that there is a moratorium from when you can institute infringement proceedings, which is also provided for in Section 44. So you can only institute proceedings for infringement of your patent after 9 months from the date of grant, unless the Commissioner grants leave to appeal to do away with this moratorium. So you cannot institute infringement proceedings within 9 months from the issuance of the letters patent document, which is the date of grant, unless you seek condonation from the Commissioner of Patents at good cause, with good cause shown. So something to keep in mind. Then again, just another practical example of what the patent journal looks like and what is actually published in the patent journal. So just the cover page, along with the application patent number, the priority filing dates, the filing dates of the application, the classification, who the applicant is, who the inventors are, the priority claims, the title, an abstract, and along with a drawing of what the invention is. Okay, and this is very beneficial for searching purposes. So if you are an inventor and you wish to see if something exists similar to the invention that you are developing, you would first conduct a search, hopefully, to see that you won't infringe on anybody's existing rights. And a good starting point is to search the records at the patent office, either by going to the patent office and working through their records, or scanning through the patent journals as well. There are obviously databases available in practice specifically to conduct these searches for novelty. Even Google searches, Google Patents, eSpaceNet are all tools that are used to conduct searches to see whether an existing patent already exists, so that you don't possibly infringe on somebody else's rights and that you do have the freedom to operate within the country where you wish to patent your application. Okay, if we then move on to Section 39. Section 39 provides for another form of a patent application that may be made to the patent office, and this is for a patent of addition. Now, a patent of addition can be applied for basically at any time So either where there's an existing application or after grant. So a patent of addition is an application that is made in addition to an already existing application or a patent. And the reason why you would do this is if there's any addition or modification or improvement to the invention which is not already disclosed in the patent specification. Let's refer to that as the parent patent or parent application. Then you can include that by way of a separate application that is a patent of addition, but they are linked together. Although you will be issued with the separate application number, it is linked to the parent patent. Okay, so if we have a look at section 39 more closely, it says where a patent for an invention has been applied for or granted. So that basically indicates at which stage you can apply for patent of addition. And the applicant or the patentee applies in the prescribed manner. So again, just an application to the patent office in respect of any addition to, improvement in, or modification of the invention described or claimed in the complete specification of the main invention. He may be granted a patent of addition. So in this way, you are obtaining patent protection for that improvement or modification to your already existing invention. So if, for instance, we take a look at the bottle and cap example again earlier, where you have a patent for the bottle, but you have now an improvement to the bottle by closing the opening of the bottle by way of this cap. This will be considered an improvement or modification to your existing invention. And this may be protected, the cap itself, by way of a patent of addition. So you see it is related to the parent patent itself. However, the term of protection for the patent of addition, so for the cap, will only be the same term as that of the parent patent. Okay, so this is the next bullet that we have a look at. The period for which such patent of addition shall be granted is the remainder period of the patent of the main invention as is unexpired. So you aren't granted 20 years from the filing date of the patent of addition. It's only the time that is unexpired of the parent patent for which you still have monopoly rights over that modification or addition or improvement to the main invention. The benefits of a patent of addition is that no renewal fees are payable. Although renewal fees are relatively cheap in South Africa, it's only a few £100. So not much of a real benefit there, but fortunately, you don't need to pay any renewal fees for a patent of addition to maintain its pendency. You can request to the registrar that the main invention or that the parent patent or application be revoked and that the patent of addition then be considered the main invention. So you can dismiss your previously filed application or patent, and that's the patent of addition with the improvement and the parent patent are then considered as the main invention. In which case, renewal fees will then be payable on the patent of addition. Okay. Again, what I've just reiterated regarding the renewal fees. If you file an application for a patent of addition before the parent application is accepted, the parent application first has to be accepted by the patent office before the patent of addition is accepted. So it's not possible for the patent office to first accept the patent of addition and later the parent patent. It has to work the other way around in the order of events. Importantly to note is that the grant of the patent of addition, so once the patent of addition is granted by the South African Patent Office, that serves that there is inventive step in respect of that improvement or modification to the invention. So it's not possible to rely on the ground that there's no inventiveness for that improvement or modification or addition in terms of the patent of addition. So if we have a look at specific wording, it says the grant of a patent of addition shall be conclusive evidence that the invention is a proper subject for such a patent and shall not be refused, nor shall any patent be liable to be revoked or invalidated on the ground only that the invention claimed in the complete specification does not involve any inventive step having regard to the main invention. So you can't revoke the patent of addition based on the ground that it is not inventive over the main patent. And as I said, the patent of addition is linked to the main patent unless it is so revoked or abandoned, and therefore it's not possible to assign the one without the other. So if you are selling the patent, you also have to sell the patent of addition or assign it to a third party. You can't assign them separately, they have to be assigned together. Okay, so if we just quickly go through a summary of patents of addition, these can be then applied for at any time in respect of any addition, improvement, or modification to the invention. The life of the patent of addition follows the same life of the parent. Again, no renewal fees are payable unless the independent patent is revoked or abandoned. And it is possible to revoke the parent and grant the patent of addition the same filing date as the parent patent, in which case the patent of addition then becomes the parent application or parent patent. Just remember as well that the patent of addition can't be accepted before the parent is accepted, and you cannot attack it based on inventive step over the main invention. And lastly, that there's no assignment without the other. Bondle, you have a question?
Yes, please, I do. I just want to know regarding the, you said you can revoke the parent and then do the addition as the main invention. In that instance, does the time continue from the parent, or is there a new time allocated regarding the monopoly?
No, so it will still be the same time as from the parent application or parent patent. So the time won't change. The lifespan will still remain the remainder of the parent. So the patent of addition in that case is then granted basically the filing date of the patent, the main patent that was initially filed.
Okay, thank you.
Pleasure. Okay. If we then move on to divisional patent applications, this is another form of a patent application that is permissible in terms of South African law and in many other foreign jurisdictions as well. You may recall that a patent application may relate to one invention only. However, many times you'll come across a patent specification that claims more than one invention. So again, using the bottle and the cap example, there'll be a claim directed towards the bottle and a claim directed towards the cap. These are two separate inventions. And in which case the act says that it's not permissible to file an application containing more than one invention. However, if that does happen in South Africa, there's no recourse. You can't revoke the patent on the basis that it comprises more than one invention. However, there is the view that it might not be clear what the actual invention is which the proprietor is seeking to protect and what the scope of the monopoly is. Unfortunately, there's no case law on this and how the courts will interpret that provision, but it is expressly provided that there is no real recourse if an application does comprise more than one invention. But it does arise in practice very often where the specification and the claims do claim more than one invention. And in that instance, where this unity of invention, as it's commonly referred to in industry or in practice, where there is a unity of invention objection possibly raised in other countries, it is possible to divide the application. So what you would do is you would then, where you have the application for the bottle and cap, you will divide the application and file a new divisional patent application where you file a separate application for the cap and retain the claims for the bottle only. So it's a splitting of that application or that invention into its separate divisional applications. Okay. So where it relates to more than one invention, you then have certain patent protection over the separate inventions or components of the application that you have filed initially. And this is provided for in section 37. So where at any time after an application has been lodged at the patent office and before it is accepted, so very important to note that date, is that you can only file a patent or a divisional patent application before the parent patent is accepted. So prior to acceptance, you can make application for divisional application. If we continue on, then it says a fresh application is made in the prescribed manner by the same applicant in respect of part of the matter disclosed in the first mentioned application. So you can't add new matter. There must have been a disclosure of what you seek to protect in your divisional application in the parent application. Then the registrar may, on application made to him, before the application is accepted, direct that such fresh application be antedated to a date not earlier than the date on which the first application was lodged. So the divisional application filing date will be antedated. So it is dated back to the filing date of the original application. So what you'll end up with is two separate applications. So instead of one application that claims both the cap and the bottle, you will have two that in separate patent applications that lead to two separate granted patents, one directed to the bottle only and another towards the cap only. However, the filing date of the cap will have the same filing date as that of the bottle. Then section 37.2 says that a patent granted on such fresh application shall not be revoked or invalidated on the ground only that the invention claimed in such fresh application is not new, having regard to the matter disclosed in the first mentioned application. So you can't revoke the divisional application for the cap based on the disclosure of the cap in the parent application. So the parent application isn't considered prior art in terms of novelty when assessing the cap. And this is something that is very commonly used in practice where a divisional application is filed. There is contention as to whether it is possible to file more than one divisional application, or whether a divisional application can be filed only from the main application for a patent. There are different schools of thought. My school of thought is that you can file multiple divisional applications because of the wording in section 37.1 that refers to a fresh application. There's no provision that says you can only file from the parent application. So my view is that you can file a divisional from a divisional and so forth. Others are of the view that you can only file one divisional application from the parent itself. There was a case that dealt with a divisional application and the requirements of a divisional application. And this was the Pharmadynamics case versus Bayer Pharma. And yeah, the court just said that the claims of the divisional application must not be coterminous with the claims of the parent application. And what this basically means is that the claims cannot be the same. So you can't have the same claims in both applications for patent. They have to be separate claims. They must be different. There may be overlap, but they cannot be coterminous with those of the parent. Again, it's also possible that the scope sought in the divisional application can be wider than the scope of the parent application. Does anyone have any questions regarding divisional applications? Fine. So it's quite straightforward. So in practice, when you're filing a divisional application, it's again filed on a Form P1 together with your Form P2, together with the Form P8, your specification, your claims. The only differences are that you will file an application requesting that the application be antedated, and then you'll also submit requests for acceptance deadlines to be extended forward. So then if we have a quick look at the term of the patent, as you all know now, it's 20 years from the date of application, but just bear in mind that the date of application for a national phase application is the international filing date and not the local filing date, as is indicated in section 35 below here. Okay, so the next section that we have to deal with is renewal fees. I'm not too sure, should we continue with renewal fees tomorrow, or would you prefer to complete it today? Consensus, give me a hands up if we should finish renewal fees today. Okay. It's not really majority, but it seems as though we should continue with renewal fees unless I receive any objections from anyone. Thanks, everyone. And then that will be the end of today. So let's then quickly move on to renewal fees and when these are due and payable in order to maintain the patent in force in South Africa. So generally, renewal fees are payable within 3 years from the filing date, and then annually thereafter. So remember, again, I can't emphasize this enough. The filing date is considered differently for a national phase application and for a complete application. So the local filing date for the complete application is the date on which the renewal fees date is calculated from. So 3 years from the filing date of that application in South Africa. However, if it's a national phase application, the 3 years starts from the international filing date from which your first renewal fee will fall due. So that's the general timeline from when renewal fees are payable. It's 3 years from the filing date, either the local filing date for completes or the 3 years from the international filing date. And then that is payable every year thereafter. Saskia, do you have a question?
Hi, no, sorry, I don't know why my hand is still
Okay,
up.
no, it's no problem. Okay, so if we have a look at section 46.2, it says a patent shall lapse at the end of the period prescribed for the payment of any prescribed renewal fee if it is not paid within that period. So as I mentioned, that period is 3 years from the filing date or international filing date. If it isn't paid within that period, your patent provisionally lapses. However, a further 6-month grace period is permissible in which you can then pay the renewal fee. So it's a provision to allow for the late payment of the renewal fee, but it's only a 6-month period. Once that 6-month period is missed and you haven't applied for the late payment of those renewal fees, then the patent is considered lapsed. Okay, so it's provisionally lapsed if it isn't paid after 3 years before expiry of the 6 months. After that 6 months expires, the patent has lapsed, in which case there is also opportunities for the restoration of the patent, but only if certain requirements are met. But we'll deal with those a bit later on tomorrow. So if we just go through this again, the patent shall lapse at the end of the period prescribed for the payment of any prescribed renewal fee if it is not paid within that period, provided that the registrar may, upon application and subject to the payment of such additional fee as may be prescribed, extend the period for payment of any such fee for a period not exceeding 6 months. So if we have a look, you've got your application date. The application proceeds to grant within 3 years from the application date, your first renewal fee will fall due. If it's not paid within this 3-year period, you have an additional 6 months within which to pay that renewal fee. In the case where an application proceeds to grant after that renewal fee becomes due, then that renewal fee will be due upon grant. So as soon as that application proceeds to grant, and a renewal fee should have been paid while the application was pending, then that renewal fee that would have otherwise fallen due has to be paid as of the date of grant in terms of Regulation 48. Okay, so if we have a look at Regulation 48, it says that if it is desired at the date of sealing or at the expiration of the 3rd year, or at the expiration of any succeeding year, so any renewal fee that should have been due, the renewal fees shall be paid before the expiration of that year. And that means that as at the date of grant. If we then look at Regulation 67I, it's only applicable to national phase patent applications. And this can be quite confusing at times, because it says if a patent issues on an application filed in terms of Section 43, which is a national phase application, 3 months or more before the expiration of 36 months from the international filing date, then Regulation 48 shall apply. So if a patent issues before 33 months from the expiration of the international filing date, so if grant occurs in the 32nd month or 31st month from the international filing date, then renewal fees are payable as per usual. The first renewal fee will be due on that 3-year anniversary. However, if we then look at subsection 2, if a patent issued on an application after the expiration of 36 months from the international filing date, or less than 3 months prior to such expiration date, the patentee shall pay any renewal fees payable in terms of Regulation 48(1) within 6 months of the date of publication in terms of Section 42, or such further period as the registrar may in terms of Section 43(2), and in compliance with Regulation 48(3) allow. So quite a lot to take in here. But if we have a look here, the crux of that subsection 2 basically is that, and we're looking, sorry, let me just get my bearings quickly. So we're looking at the slide, or this illustration over here in the middle. And basically what it infers is that if grant occurs more than 33 months from the international filing date, then the patentee is provided with a 6-month grace period from the date of grant within which to pay that renewal fee. But they are also afforded the additional 6 months provided for in terms of Section 46(2). So in effect, they have a year within which to then pay that renewal fee. provided that grant occurs after 33 months from the international filing date. So if grant occurs prior to 33 months, then that renewal fee falls due as per usual on the 3-year anniversary. However, if grant occurs after 33 months, then that renewal fee is payable 6 months from the date of grant with an additional 6-month period. Mpo? Maluleka? Is that correct? You're right, huh? I need confirmation of this.
Yes, you are.
Fantastic, thank you. Okay. So don't be too perplexed by the extensive wording of this act. It basically just implies then that once the patent proceeds to grant after 33 months from the international filing date, that you are given a free 6-month grace period from the date of grant to pay that renewal fee. So in this case, no late fines are payable, but you're also afforded the additional 6 months within which to pay that renewal fee. But in this case, you will have to pay the late fines for that additional 6-month period. And that brings us to the end of today's workshop. Hopefully tomorrow will be a bit more riveting. We'll be looking at revocation, restoration, infringement, things that are a bit more of substance and not so procedural and formal. Are there any questions that you might have for me from today's session? Jabulani, you have a question?
Yes, I just wanted a clarification on the main application and divisional application. Do you have like a copy which you could check just to have it better understand?
A copy to check between the two?
I mean, yes, something so that we have an idea, because I'm trying to break my head and say what is divisional and something like that.
So the divisional is a fresh application. It's a separate application. It just stems from that main disclosure of the original application. So, you know, it's if there's the disclosure for both inventions in this patent specification, you know, but this is not granted patent. So just consider that this is your application and it contains more than one invention. You will then apply for a new application before this one is accepted in order to include the separate, so basically dividing up that invention so that you then end up with 2 patents. Okay, so you'll have 2 separate patents then. The one is just the divisional of a previously filed application. So in this case, in most instances, the specification, the description itself, will be exactly the same for the parent application and for the divisional application. The only real difference lies in the scope of the monopoly and the claims. So your claims will then be different because the one will then be towards the bottle only and the divisional will be for the cap. So initially, when you filed your patent application in South Africa, it comprised of 2 inventions. So claim 1 read a claim for a plastic bottle, and claim 2 says I claim a plastic cap. Okay, so it's 2 separate inventions. But what you're doing by filing the divisional application is that you are excising the cap from the claims of the main invention or the main application and filing it as a separate application so that you end up with 2 completely separate patents granted at the end of the day. Does that make sense, Jabulani? Fantastic. Thank you.
Thank you. Thank you.
No problem. Are there any further questions that I can address before we head off? Okay, it seems not. With that, thank you everyone for your time today. Thank you for enduring it with me. It is a long day. It is a lot to absorb, but I do wish you well. And then I will see you all tomorrow morning at 9 o'clock back on Teams. Please do think about what we've worked through, and if you have any questions, I'll address those tomorrow morning before we continue with the remainder of our workshop tomorrow. So have a lovely afternoon, everyone. Thank you again for your attention and for joining me today. Have a good afternoon. Take care.
Thank you.
Thank you very much.
Thanks, Marco.
Thanks, Rob.
Bye.
Thanks, bye.
Bye-bye.
Bye-bye.
Bye.
Thanks,
Thank
bye-bye.
you.
You.